Hello and welcome to McDermott's session number 3 in its Return to Work series, our virtual toolkit for employers regarding returning employees to work. I'm Ron Holland, a member of McDermott's global employment practice and based in the San Francisco office, and I'll be your moderator today. Before I introduce the panelists, let's get some logistical issues out of the way. First, if you have any questions during the webinar, you'll see a Q&A icon at the bottom of your screen. Please use that and submit your questions. Time's tight, but we'll try to get to as many questions as possible, both during and at the end of the presentation. Second, a link to the webinar and a recording, as well as the slides, will be available to all participants at the end of the webinar. Remember, for you lawyers, this is a CLE credit program. It's important to fill out the survey that you get after the program and submit the required information if you want to get your CLE credit. For those in New York, towards the end of the program, I'm going to give you a validation code. You're going to need that validation code, again, for your survey in order to get your CLE credit. And then finally, we do have our McDermott website, our coronavirus website. It's a fantastic resource center at mwe.com. Just go to the drop down on coronavirus and you'll find much of the information that we're presenting today, as well as a ton of other very helpful information available to you on our website. Without further delay, let's get started. As many of you know, as you all know, coronavirus has upended businesses as they run today. Some employers were permitted to continue to operate as essential businesses. Others were completely shut down. And then many, like ours, modified to allow workers to continue to work remotely and keep them safe while continuing their operations. As shelter-in-place orders start to loosen and the states start to reopen, businesses are also starting to reopen. But business as usual, I think, is gone. If not forever, it's gone certainly for quite some time. In this series, in the Return to Work series, we're going to explore legal and practical obstacles to the legal landmines that you'll face and the practical obstacles that you'll face in reopening your businesses, regardless of industry and regardless of geography. Today's webinar specifically focuses on those issues that you will encounter as you return your workers and employees to the workplace, the selection process, the issues regarding wage and hour, the issues regarding discrimination and harassment, and in some cases, as you realize that your business isn't going to open completely, the WARN obligations that you may face. Many of you face those WARN obligations at the beginning, but now we're seeing them reappear. I'd like to introduce my colleagues before we get started. First, Ellen Bronchetti, a partner in our San Francisco office, Lindsay Ditlow, a partner in our New York office, and Julie McConnell, an associate in our DC office. Can we go to the next slide, please? Just as a reminder, this is the third of the webinar series, and we've got a few additional webinars coming up, 4, 5, and 6 over the next couple of weeks. You'll see session 4, preparing your responses, which has to do with training, handling those safety complaints, the ADA accommodations that we expect you to see. Session 5, I'm sorry, session 4 will be next Tuesday. Session 5 will be the following Thursday, and then after that, section 6, which is anticipated litigation. I'm sure you're all looking forward to that one, but it will be the culmination of this entire series, and we'll try to rely on all of the information that we've presented over the first 5 webinars and additional information that we've received from various federal, state, and local agencies, and spot some of those landmines and pitfalls that we see with regard to potential litigation. At this point, I'd like to turn it over to my partner, Ellen Bronchetti, to discuss discrimination and harassment pitfalls that you are likely to encounter as you return your workers to the workplace. Ellen?
Good morning. Thank you, Ron. Discrimination and harassment has been a concept that all employers are very familiar with coast to coast. What's challenging at this point is we have old laws and also new laws coupled with new anxieties and new challenges, both for employers and employees, that make looking at discrimination and harassment almost with a new lens that's never before been challenged. May I have the next slide? We're all familiar at this point with the protected categories under federal law. And if you live in a state such as California or New York and New Jersey, I'm sure that we couldn't even fit all the categories that are protected on this slide. But I bring up this slide to say that we've always, you've spent decades crafting policies, practices, procedures to ensure that workers are not discriminated against or harassed based on a protected category. Those policies all need to have a fresh set of eyes given the new challenges and new protections that have resulted as a result of this global pandemic. May I have the next slide, please? In addition to new protected categories, which I'll talk about in a minute, I also believe that there are some already protected categories that are going to start seeing more of a spotlight as employers figure out how to return a portion of their workforce or all of their workforce in the months ahead. This graphic here shows you that currently 20 states have protections for employees based on marital status. 3 have protections for family status. 1 has protection for parental status. In a year from now, I do anticipate that this graph will look quite different as states continue to adopt to new laws, new realities, and new policies and practices in the workforce that are caused as a result of unprecedented closure of schools, challenges at home, trying to figure out how to accommodate all employees, family, parental, and marital status, which is implicated more so than I think it's ever been before with this pandemic. May I have the next slide? In addition to the federal laws that put individuals in various protected categories, the state laws, we are also seeing a resurgence of issues arise under the FMLA. As you probably know, the FMLA is the federal statute that allows employees to take protected leave for themselves or their family members for a serious health condition. There's been a significant rise already in FMLA claims where employers may unknowingly not be administering those policies and laws properly. We also have new regulations that have been issued, for example, the Family First Act, which requires employers with less than 500 employees to provide paid sick leave and expanded family medical leave for those workers who have to care for their family members as a result of COVID-19 or the school closures. On top of that, there has been a barrage of new state statutes and local ordinances that are similar to the FFCRA. Sorry, there's a typo there. FFCRA, including statutes that have been issued in New Jersey, New York, Washington, Michigan. Those statutes have been sent out at warp speed, which now prohibit discrimination, harassment, and retaliation based on an employee having COVID-19, not being able to work as a result of having to care for a family member who has COVID-19 or may have the symptoms of COVID-19. Cities such as San Francisco, Los Angeles, New York have also implemented their own statutes which apply. We see this as a sign of things to come, as this pandemic does not look like it's going away anytime soon.
Ellen, if I can just jump in, I mean, that was a great summary of these 3 categories here, and I know that in session 6 we're going to look at litigation, potential litigation, but what other trends are you seeing? I know your practice is national, not just in California but nationwide. What other trends are you seeing in litigation out there? Is there anything common, or even as opposed to trends, anything unique that you're seeing?
We have already seen an uptick in cases that are being filed under the Family First Act for denying employees the leave that's protected by the statute. We're already seeing an uptick in ADA accommodation cases and FMLA cases. Surprisingly, and it's just the beginning of this long story, we haven't seen as many wage and hour claims yet. Hopefully we won't, that trend will continue. But what I do think is interesting in states like California, Illinois, Florida, and New York, already we're seeing a strong uptick in these types of cases, and we anticipate that to endure for quite a long time. The Families First Act, unlike many of the discrimination laws which require exhaustion, meaning you have to go to a federal or state agency before you have access to the courts, that act does not require that type of administrative exhaustion. So employees can have quick and easy access to the courts where they believe their rights have not been respected.
Thanks. I think we're about to have some fun here. I think we've got a polling question for our audience. For the participants, we are going to have polling questions throughout. If you attended the first few, yeah, you realize that these will pop in along the way. But here's our first one. Are you asking employees to voluntarily self-identify if they're in a risk category and offering those employees in the category to stay home until a later phase of return of work? If you could answer now, please. The results will come up shortly. The results are up. Ellen, can you see those? They vanished from my screen.
I can see those. 30% of respondents answered yes, 29% said no, 34% undecided. This is one of those questions that it's a tough call. You know, we understand that employers who answered yes are very well intentioned. They want to make sure that their workforce, especially the workforce who's in a higher risk category as defined by the CDC, feel protected, feel like they are valued, feel like they are able to stay home. As an attorney, it makes me nervous because I also can see the risk that is involved with making that very well-intentioned offer to employees. An offer like that could be viewed as exclusionary to those people who may not fall into those categories exactly, but who also may have other circumstances such as anxiety, unspoken anxiety, depression about going back to work, fear. And so those types of practices may be unintentionally viewed as exclusionary to some of the workforce who may be in the same boat, but it might not just fall into one of the categories as identified by the CDC.
Yeah, I was going to say, I think that that's a great observation. That's why you're seeing that almost equal split between the categories. I'm not seeing it because my chart's gone, but I think that that's why you're seeing that almost equal split there, where employers are sort of divided as to what they're going to do because of the points that you just made.
Right, and other employees, who may fall into those risk categories might suddenly feel a pressure to disclose a condition that otherwise they were not ready to disclose, such as being pregnant or having diabetes, that an employer may not otherwise have any reason to know at a certain time about a medical condition. And so, of course, we're not saying that you should not do that, but any of these policies, you really have to look at with flexibility, creativity, and having open doors of communication to make sure that whichever employee you have feels like they're protected and supported in whatever decision they may make to come back to work, how they come back to work, and the circumstances in which they're comfortable coming back to work. The key for the 4 points, there are a lot of things to cover, discrimination and harassment, but what I believe is that employment-related decisions are going to be subject to heightened scrutiny And that's especially true here, given that many employers are likely making decisions that only impact a portion of their workforce. Reading the CDC guidelines that were issued, oh, geez, was it yesterday? I think it was yesterday, or 2 days ago, that talk about what employers have to do to come back. The fact is, many employers, it's just impossible to bring 100% back on day one, even 50% back on day one. And so the decisions that employers are making, I believe, are going to be scrutinized like never before, which is why it is so important in our view that an employer, get together and put together a very detailed written plan about how are we going to call people back, what criteria are we going to rely upon, and have that crystallized before you start making decisions about which employees get to return first, which don't, which get which accommodations, and which may not. I find that to be most critical, more so than ever before, given all the various pressures that our employers and employees to return to work, but do so safely. Like it's always been, and any time you make employment decisions, obviously, the more objective you can be in your selection process, focusing in on what are our operational needs, what do we need to drive performance, what do we need to deliver for our customers, making sure that those are outlined and connect those objective factors with who needs to do the work in order to achieve that objective, in my view, is one of the best ways you can draft a return to work plan that meets objectivity standards. Past performance problems, obviously that's probably a factor in many of your decisions, but you really need to do a gut check when you're looking at your return to work policies, procedures, and selection process to make sure that those decisions were correctly documented, fairly documented, and consistently documented before you rely upon them. And obviously, seniority is also, one of those factors that it's very difficult to argue with the objectivity of seniority. I also want to mention unconscious bias. Unconscious bias has always been a critical component of developing non-discriminatory policies and procedures that hear the perspectives of many people. We're in an interesting time where we're not at our workplace, but we also have to make sure to include employees in the decision making to make sure that whatever new policies, new guidelines, new procedures, new return to work practices, whatever you implement, have been vetted to make sure that employees across all diversity categories have had their voices heard. There's also an issue with equal access to resources, which many policies might not consider. One way you may want to accomplish, looking for unconscious bias in new policies and procedures at this time is to conduct employee surveys, to get feedback, to ensure that employees feel like if they believe a policy, while perfectly well-intentioned and legitimate, improperly harms one portion of the workplace where there's a channel for that employee to speak up. Communicating those channels to employees is critical at this point as employers are making return to work decisions, creating policies at rapid fire pace. Can you go to the next slide? We also think, and this will be covered in great detail in our next webinar session, but we certainly anticipate an increase in requests for accommodation for disability, for religious purposes, particularly when it comes to wearing masks, having to comply with certain infection control requirements. Of course, the interactive process has not gone away, and the EEOC continues to issue important guidance that is intended to help employers deal with the challenges of increased requests for accommodations, increased concerns with employees who may feel unsafe or at risk or have anxiety about coming back to work. And those guidelines are an important read because they offer several practical and realistic responses and recommendations for employers. And so that will be important that employers are familiar with. Of course, the theme in all of this guidance that's issued by the EEOC is flexibility and to avoid blanket exclusions. Know when you draft a policy, expect that there will be multiple exceptions that need to be made to the policy, and it's critical that you work with employees and engage in the good faith interactive process more so than ever, and that starts with conversations. The EEOC, one I think interesting thing that I've received quite a few questions about from employers is if you implement a work from home process as an accommodation at this point, does that create a precedent where you have to continue on with the accommodation once the pandemic has ended? The EEOC has come out with interesting guidance, which I think is very important for employers to pay attention to, which is you can make temporary accommodations that have a date certain expiration date. And the EEOC is not going to look at a temporary accommodation as precedent that has to be continued once this pandemic ends. There's also this ongoing tension between the ADA and OSHA. The EEOC has said employers may not ask employees who do not have COVID-19 symptoms to disclose whether they have a medical condition that the CDC says could make them vulnerable. We have that challenge, but as you've probably heard on previous webinars, that there's also this tension with OSHA that you have an obligation to keep your workforce safe. And so understanding the fine line between the limitations of the ADA and OSHA going forward will be critical. And of course, you must maintain medical information collected about employees and applicants, confidential, separate from their personnel files, consistent with the ADA. Again, another extreme burden that's placed on employers, especially in this unusual time.
That's okay. I think we have another polling question. Ellen, if we could pull up the polling question. If you're only returning a portion of your workforce, are you conducting or have you conducted an impact or a disparate impact analysis? If you could answer now. Just seems to take so long to get those answers. There we go. We've got 12% who have, whether formal or not, 52% no, and 36% undecided. Does that surprise you, Ellen?
It certainly does not surprise me. However, I think there are different types of impact analysis. There's a formal impact analysis done in the way that the EEOC prescribes, but through a statistician doing very technical mathematical calculations. But I do think, because of the challenges that are presented right now with the fact that employers are only returning, for the most part, a portion of their workforce, while a formal impact analysis does not always need to be done, I think at any time when you're only returning a portion of your workforce, you need to do I'll call it a gut check analysis as a starting point, to make sure that your returning workforce reflects the diversity of your complete workforce. And if you start to see that there happen to be wide disparity in, you just happen to have an equally distributed workforce based on age, and suddenly only the younger people are coming back, that requires a much closer look. And the other thing to think about when you're considering whether to conduct a impact analysis, whether formal or informal, is the level of subjectivity that you're relying upon to reinstate people. The more subjective your return to work selection process is, I think the more important it could be to do some form of impact analysis. The other point that I just have to mention, so I don't have anxiety about impact analysis, is they may be discoverable whichever, whether you do a back of the napkin impact analysis or something more structured and complete. And so you should work with legal counsel to make sure, however, these types of analysis can be protected where appropriate. And I'm going to turn it over to my colleague, Julie.
Thank you, Ellen. As Ellen mentioned, the EEOC throughout the last couple of months, and even as recently as a couple of weeks ago, has continued to provide really helpful guidance for employers on what they can, cannot, and perhaps should or shouldn't do as employees are both in the workforce and as you're thinking about bringing employees back into your business. So in light of the most recent technical guidance that the EEOC has put out, I thought it would be helpful to talk to you about what the EEOC has said you can do, as well as some limitations on that as you are bringing employees back, and specifically to avoid any potential violations of the ADA. So it hopefully goes without saying that if you have an employee who is sick, who has symptoms of COVID-19, or certainly who has been diagnosed with COVID-19, that individual should not be coming in to work, and the EEOC has said that under those circumstances you can require that person to stay home. That hasn't changed in light of the fact that stay-at-home orders are being lifted. Secondly, hopefully you're all aware that temperature checks and symptom screenings are something that the EEOC has said that you can do, that you can administer. And as it pertains to temperature checks in general, the agency has provided some really helpful guidance that you should consider. So ordinarily, a temperature check would be considered a medical examination, and the law puts very strict requirements around when an employer can and cannot perform a medical exam or require one to be performed for an employee. But, as we all know, these are not necessarily ordinary times, and the EEOC is recognizing that given that the CDC and other public health authorities recognize and have really talked about the spread of this virus and how dangerous it can be, that temperature checks are not only advisable, but really something that you should be doing as you are bringing employees back so that you protect your business, your employees, as well as maybe any patrons that you may have that your employees come into contact with. And also helpfully, the EEOC has specifically said in their most recent guidance that the ADA direct threat defense will apply in circumstances where an employee has symptoms of COVID-19 or has been diagnosed. And just as a reminder, what the direct threat defense provides is a defense to you as an employer that given the significant risk of health or safety, both to employees as well as to other individuals that they may come into contact with, that threat cannot be eliminated by any sort of reasonable accommodation that might otherwise be provided. So to the extent you are making decisions about whether to, for example, require someone to stay home because they have a temperature, or perhaps even other symptoms or a diagnosis of COVID, this defense will protect you in the event that some sort of litigation is coming your way down the line. Now, taking a slight step aside from the EEOC guidance, there are some other laws that you should think about as you're deciding whether or not to conduct or to require any sort of temperature screening. And the first is whether the state or states in which you operate have any biometric privacy laws. So as an example, Illinois has a statute that requires private entities that collect or retain or disclose any sort of biometric information to actually get consent in advance from the individual before they collect that information. Now, why is this relevant to a temperature screening? There are certain devices that we are seeing being talked about in the news, for example, a thermal scanner that you can use to conduct a temperature screening. But depending on the device and sort of the background technology in it, that device may actually be collecting some biometric information of an individual, which could be protected under a statute like Illinois'. And just as another fine point on this, Illinois statute, for example, requires that if you collect this type of information, that it has to be retained in a certain manner. It has to then be destroyed at a certain period of time. And if there are violations of the statute, it creates a private right of action as well as the potential for statutory damages. So again, just be mindful of whether your particular state or states have these type of laws that could be impacted by a simple decision of what type of device you're going to use to check temperatures. And sort of in a similar vein, some states have data and information security laws for information that is collected in a computerized fashion. And you want to be aware of the fact that there could be a data breach notification requirement in the unlikely and unfortunate event that any information you might collect is subject to a data breach. So again, these are just things that you should be thinking about as you're trying to decide what type of device or technology you might be using to conduct temperature screenings. Now moving back to the EEOC guidance, the EEOC has also said that you can conduct other medical examinations, and I want to make sure that I get the language on this right, because I think it's really quite important. It must be job-related and consistent with business necessity. And they're also suggesting that any sort of medical examination that you perform or require be as accurate and reliable as possible, following FDA guidance. Now, as it pertains, for example, to certain types of COVID tests that we're seeing out there, you've probably heard that there are certain false positives, false negatives that are resulting from these different types of tests. So it will be extremely important as you are deciding whether to require or perform any other type of medical exam, not only that you make sure that you're following the strict parameters that the law already requires, but that you're also keeping in mind what the most recent FDA guidance is. And just finally, the EEOC has continued to clarify and confirm that you can require employees to provide a doctor's note certifying fitness for duty when they return to work. But as a practical matter, you may want to think about whether you should or can relax some of your ordinary policies that you would have around this. So it can still be quite difficult to get in to see a doctor or a nurse practitioner or other medical provider right now. And perhaps whereas you might ordinarily require a wet signature on a note, you might want to think about whether an email note or even a form that could be stamped would be advisable and easier for the employee and the medical providers at this point in time. Now, finally, the EEOC has also provided some really specific guidance on new employees or ones that you might be considering for a particular job opening. So just as you can with an existing employee, for an applicant, you can screen that applicant for symptoms. You can require a temperature check. You can even delay a start date if that particular individual is symptomatic with COVID or has actually been diagnosed. And if an individual were to need to start immediately, the agency has said that you can actually rescind the offer if the fact that their symptoms or diagnosis of the illness would prevent them from actually coming into the workplace at the date that you need them. But just to put one more fine point on it, you cannot postpone a start date for an individual who is at higher risk simply because they are at higher risk. So that would include someone who maybe is over 65, someone who is immunocompromised. Now, if that individual, for example, wanted to work with you to postpone a start date because they're nervous about entering the workforce, that would be a different analysis. But you as the employer cannot categorically just postpone a start date because someone falls into one of those categories. And finally, just as with any reasonable accommodation request, as Ellen mentioned earlier, to the extent you collect any medical information about employees and applicants, you still need to maintain that confidentially and separate from any personnel record. And if we could go on to the next slide. You know, as I'm sure all of you know, your obligation to prevent against workplace harassment and discrimination doesn't end when an employee walks in the door. That obviously has not changed given the circumstances that we find ourselves in. But COVID also presents some really unique challenges when you think about having employees in the workplace and how to protect them against any sort of potential harassment or discrimination. And we anticipate that as employees do return to work, that there will be an uptick in discrimination and harassment litigation as it pertains to individuals who are having experiences in the workplace. Now, whether those claims have any merit to them or not, here are a couple of practical tips that you can think about to protect yourself or to avoid litigation, or in the unfortunate event that any litigation may be filed against you, to help you to combat that and have a really good defense. So the first is, you know, continuing on the theme of policies. This is a really excellent time to refamiliarize yourself with any harassment or discrimination policy that you have, or if you do not have one, to put one in place. And obviously you should work with legal counsel to do so, but to the extent you have any policy, you should be thinking about, does it have a reporting structure? What does that structure look like? And if an individual has a concern about harassment or discrimination, within the reporting structure, can they speak to someone who is outside of their immediate chain of command, such as an ombudsman or someone in HR or even a general counsel's office? There should be no punishment for reporting. You should promptly investigate any complaints, and to the extent there is validity to those complaints, there should be consequences, up to and including potentially, you know, suspension, termination, or other consequences. But a plan, of course, you know, has no merit if you don't follow through on it. So you should be clearly communicating these policies to your employees. Communicate to them that just as it was before COVID, now that we are reopening, we're not going to tolerate harassment and discrimination in the workplace. It's illegal. And that, for example, why it might be valid to be afraid of the virus. You know, many thousands of people have become sick, very sick. Many thousands of people have died. That fear about the virus should not be misdirected against an individual because they, for example, fall into a protected category such as age or gender or race or national origin. You should also be wary of treating people who both choose to come back to work and those who may continue to work from home. Be mindful of making sure not to treat them differently. So, you know, worst case scenario, you don't want to have someone who is choosing to continue to work from home that you allow to, but maybe that person does not get the equal opportunities that someone who chooses to come back to work does. And finally, in continuing to communicate your policies, you should think about whether any additional training for supervisors might be appropriate, particularly as it pertains to how to conduct investigations, how to respond to individuals if they have particular concerns. And with that, I'm now going to turn it over to Lindsay, who is going to discuss some potential issues with warrant obligations under federal and state law.
Thank you, Julie. If we could go to the next slide. Excellent, thank you. So for those generally unfamiliar with what is known as the Federal Worker Adjustment and Retraining Notification, otherwise known as WARN Act, I will start by giving a bit of background and overview of employers' obligations under WARN before addressing some of the unique COVID-19 implications of WARN and scenarios dealing with repeat or extended furloughs and layoffs, which have, you know, kind of been occurring over extensions of stay-home orders and the like. So WARN requires employers to provide advance notice and planning to their workforce and community in the event of a qualified plant closing or mass layoff. What this means is specifically under federal WARN, and I preface federal WARN because I'll get to the state mini WARN Acts a little later, employers with 100 or more full-time employees, and this is total employees across all sites and locations, must provide at least 60 days written notice in advance of such covered plant closings and mass layoffs. There are a few specific circumstances that trigger this WARN notification requirement. The first, as mentioned, is a permanent or a temporary plant closing. This is what affects at least 50 full-time workers at a single site. A plant closing under WARN will also be triggered when an operating unit has fewer than 50 full-time workers, but other layoffs occur in the plant as a whole that make the total number of layoffs 50 or more. The second is layoffs, which under WARN means, well, 50 or 500 or more full-time workers at a single site over 30 days, or layoffs in the amount of 50 to 499 full-time workers when the layoff constitutes 1/3 of the total full-time workforce at the site. Additionally, and I'll touch on this in a little bit more detail later, there are a few exceptions to WARN. As you can see on the slide, these are found at 29 USC 21OB, 2A, and then B, and they provide that an employer may order plant closing or mass layoff before the conclusion of the 60-day period if it's caused by unforeseeable business circumstances, faltering company, or natural disaster. Okay, next slide.
I think, yeah, before we go, I think we have another polling question or a pop quiz, Lindsay. For our audience out there, tell us, does a furlough trigger WARN? Please answer now.
Okay.
Oh, look at that. We have a substantial number of maybes, right? That's good. Tell us what you think about that, Lindsay.
Yeah, actually, so we have 18% yes, 29% no, and 53% maybe. And I think those answers are good. And we have some very smart people on this webinar, although I will say it was a bit of a trick question, as really the answer can be all of the above. So if we can go to the next slide, I'll explain this a little bit more because it can be sometimes yes, sometimes no, and sometimes maybe. So as mentioned, if a temporary layoff was initially thought to last less than 6 months. So let's say at the start of certain state stay-home orders back in mid to late March. And at that time, you were only expecting it to last potentially 2 months. And however, during that time period, because of changes in business circumstances or extensions of stay-home orders, the furlough is extended, potentially even multiple times. Notice is only required to be given then when the need for an extension beyond 6 months becomes reasonably foreseeable. And that's going to be based on kind of all the circumstances at a whole at the time, taking a look and determining, if we're having to extend this now an additional month or two, is it starting to look like this will now reach the 6 month or more mark? However, if the furlough does not ever last 6 months, then no notice is required. And if at the time the furlough was originally planned, it was known that it would last at least 6 months, then notice is required at the initial time of layoff. So if any of those circumstances arise, again, where it's extended and at some point it becomes reasonably foreseeable that it would last longer than 6 months, or if at the time of the outset of the furlough, it was known that it was going to last 6 months. Under those circumstances, a WARN notice must be provided to affected employees, and then also state and local governments as applicable. And that's a lot of times how you'll want to look at your state laws, determine what the proper agencies are for that. Also, as you see on the slide, there are exceptions to WARN's 60-day notice requirement, as I mentioned, including faltering company, unforeseeable business exceptions, and natural disaster. As you may have heard or have seen, one of the big questions arise in the COVID-19 context is unforeseeable business circumstances. Next slide, please.
Lindsay, let me ask you a question.
Sure.
If you're engaged in a significant layoff now, so long after the pandemic started and has evolved. Can you avail yourself to the unforeseen business exception? And a little asterisk there also, is there a difference between the faltering business and the unforeseen business exception?
So to answer the second part of your question first, then yes, faltering company exception kind of applies when you're considering potential sales of businesses, and for whatever reason during that time it became unlikely that what was going to occur would potentially result. The unforeseen business circumstances will apply in the event of any furlough or temporary layoff which occurred in the beginning of numbers that would potentially trigger warrant. And again, it's based on the employer's reasonable business judgment. While the COVID-19 pandemic is the first situation of this kind for employers, we do know from past case law that this does not require second guessing based on hindsight. So if, a year from now, potentially there's a challenge that said, well, see everything that's happened. You should have known back in March that this would have lasted and that stay-home orders would have been extended to potentially June, July, and that the layoffs would have caused business disruptions that you wouldn't have been able to have come back by that time. That's not what it is. It's going to be looked at the time of the decision. And courts have described this by saying, as long as a company reacted the way a reasonable employer in its market, so this will kind of be within the industry and within your state and potentially city, did in the face of these occurrences, then they will be excused from warrant liability. However, still, this is going to be a kind of state-by-state, fact-specific inquiry, and different employers may be affected by COVID-19 differently. So just because another employer might be able to take advantage of the unforeseeable business exception to warn notices doesn't mean another employer will be able to. As we know, different industries will have been affected differently. Different employers, depending on the workforce, may have been affected differently, as well as their industry. So it's always going to be something that you want to take a look at, as opposed to one across-the-board answer. Next slide, please. So therefore, if you determine that either your natural disaster, which at this point I will say, I don't know if you saw on the prior slide, there's no indication that it does apply to COVID-19, but assuming other circumstances, if that warrant exception would apply, or you have the faltering company exception, or the unreasonable business circumstances, that it doesn't mean that you're excused from providing notice entirely. The exception will only eliminate penalties for providing less than your 60 days notice. And again, once a closure or layoff that would last more than 6 months is reasonably foreseeable, notice should be provided and include why the employees were not receiving the full 60-day notice. I've also included on the slide some of the potential liabilities and penalties that there may be more if such layoff or closure occurs in a state that has its own mini warrant act. So as you can see, these can include back pay and benefits for each day of violation up to 60 days, $500 in civil penalties for each day the employer failed to provide notice to the government officials, and then employees and unions, as well as local governments, all have standing to bring a challenge to your failure to provide warrant notice. Next slide. Okay. So here we're going to go, and I've, actually, I think if we could go one back. Thank you. So here's some of the states which have mini warrant acts. There are specifically 12 states that have their own mini warrant act, and they're all kind of listed on the site too, on this slide. To avoid and be mindful of the time, these slides will be available so people can kind of check in with their own relevant states as need be. But in addition to these states, there are other states that even if they have no formal mini warrant act, may have similar insurance notification or severance acts. So always work, if you're considering large layoffs or plant closures, always work with counsel, not only for your federal warrant requirements, but your state warrant and other acts to make sure that you're fully complying. Okay. And you can see, for example, some of these have even larger notice requirements. For example, just to call out New York, which has a 90-day notice period. Additionally, certain states have enacted orders or suggested that their state warrant notice requirements may be relaxed in response to COVID-19. Next slide. This slide shows that California is one of them, New Jersey is another, there's a number of other states that do have those. So just a reminder, we're always going to want to look at the state WARN Acts and what they have provided in response to COVID-19. So just on this, wanted to summarize some of the main points and takeaways. There's some, as you see here, state WARN Acts may require shortened notice periods for layoffs of less than 60 months. Examples, Vermont, New York has less than 90 days. Wisconsin has one that's actually less than 60 days. There may be forgiveness based on unforeseen business circumstances or even relaxations based on COVID-19 specifically. And then also be mindful that depending on your state, a furlough or WARN notice might trigger final pay obligations, which would include payment of accrued PTO. Okay. Again, here's just a recap. If you're contemplating a plant closure or mass layoff, or extending, again, a previous layoff either one or more times, and you're going to want to consider whether under those circumstances at that time, if you're going to need to warn. And that's going to require consideration. If so, when is it reasonably foreseeable that would last more than 6 months? When is your notice required under your federal WARN statute or your applicable state law statute? And then what do you have to warn in terms of the notice to employees? And if you're giving less than your statutory required notice provision, remember to include in your WARN notice why employees are not receiving that full notice.
I think we're on to the next topic of pay-related issues. We're going to transition to some of those thorny pay and payroll-related issues that you're likely to face as employees return to work, meal and rest period issues, hourly rate, either reduction or restoration issues, and any notice requirements that come along with that, even some of those reimbursement issues that you'll see, those odd requests for that. So let's go to the next slide. I think we have a polling question. So we'd like to know, for purposes of developing some of the talking points here as we go through the slides, have you begun to notify your employees of a return to office or return to work yet? Please provide your answers now if you can.
Okay, well, a little bit of a mixed bag. So we have 41% with yes, 28% no, and 31% not yet, but planning to. I think that probably is representative of most of the country and how things are coming out. But either way, whether there are important things to consider, whether you have people working from home or they're still on furlough or coming back into physical office space, a number of items to consider. First, if asking employees to return to the physical office location, whether this is from teleworking during this past time, or if employees have been on furlough and now that you're able to reopen, coming back into the physical office space, you want to provide written notice. And in this written notice, you want to include any key changes to schedules that may be the result of either reduced business needs or just staggered schedules to assist with social distancing. We've seen that that is one of the recommendations in order to keep people staggered in arrival departure times, as well as to potentially facilitate lessen the number of people in the office on each day. Additionally, you're going to want to inform employees of COVID-19 policies to expect, including weather temperature screening, as Julie mentioned, masks, and other PPE changes, and changes to office common areas or other spaces. Really, this is to have the employees know, one, what they can expect. They can ask questions. You can kind of work with employees who might have concerns ahead of time, and then hopefully this will ease any compliance issues. Also, if there are any wage changes associated with the return, I know while some employees, they might have had at the time initially going to telework, reduced wages, or now they're bringing people back from furlough from a business that might have been non-operational for a period of time, there might be questions and issues surrounding wage reductions. And you're permissible to make some changes to wage notices, but you always want to make sure that you do so in compliance with your state law. Many states require that wage changes be in writing and with a specific amount of time for notice. The amount of notice will vary by state. So similar to if you're working with Warren, you always want to check in with counsel if you're preparing to change employee wages to make sure to comply with applicable law.
Lindsay, what happens if you run afoul of those technicalities? The failure maybe to provide, say, 7 days notice or 3 days notice to an employee where you're going to reduce their wages?
Sure. So that also, too, is going to vary by state. There's generally sometimes specific penalties or things that can be done. Sometimes there's also back-end catch-alls. Let's say for New York, it does require a 7-day reasonable notice or 7-day notice period for change in wage. However, that's not required if it's then included on their pay stub. They're following pay stub. So a lot of times there's a way around it or catch-all to that. But there could be some penalties associated with not complying. Employees can raise the issue. Also, you could be stuck at paying their former wage for a period of time, depending on your applicable state.
I think we're on to the next slide here. Lindsay, before we jump in here, let me ask you, has there been any recent clarification from the federal government on, there's been a bunch of questions regarding how do you define a full-time equivalent position, and there's not only been questions, but there's certainly some confusion around that and what the payroll cost requirements are in order to meet your obligation under CARES. Has there been any clarification recently?
Yeah, absolutely, Ron. So one of the ways in which we saw a lot of employers recalling employees from furlough and then potentially changing wages and providing potentially additional benefit payments during this time was in response to their receipt of PPP loans. Not a full topic for this webinar, and in fact, to give myself a little bit of a plug, I am doing in part with some of our other colleagues, a webinar tomorrow, which is going to go into a number of the PPP loan requirements to kind of step on that. But there has been recent things in connection with the loan application forgiveness application, which clarified some of the issues with FTE headcount, the potential for alternative dates and everything. So if you have time and are available, please check in tomorrow at 1 Eastern time and we'll have a further discussion on that. And then just to kind of go back, I just want to touch on one thing, especially when connection with some wage notice requirements and changing things related to non-exempt and exempt employees. So certainly employers are not permitted to reduce wages below the federal and applicable state minimum wage. But when dealing with exempt employees, in order to avoid a risk of reclassifying to non-exempt status, which would make the employee eligible for overtime, then the exempt employee's salary cannot be reduced below the federal and state threshold. We also want to make sure that if they drop below this salary, even if they're still meeting the exempt employee duties test under whether the professional, administrative, or executive exemption, that they would still be reclassified and be eligible for their overtime or other breaks. Additionally, as employees return, whether just from telework or from furlough, and given changes in business needs or structure, if there's a change in employees' job duties and responsibilities, employers want to make sure that the employee remains properly classified as exempt. For example, as if they were previously managing 2 or more employees and potentially eligible for one of the exemptions, if they're no longer doing that because potential reductions in force, you'd want to reclassify them. Another exemption that might no longer come into play in light of COVID-19 is the outside sales exemption, where you're not having an employee go to client sales sites the majority of their time. So again, just want to carefully consider what the employee's job responsibilities are now given certain changes to the business. For non-exempt employees, COVID-19 doesn't change the tracking of their hours requirements and want to ensure good policies there, especially when teleworking, because I know you might not be able to see exactly what time they clock in, clock out. There are programs for that, and then also that they take the required meal and rest breaks.
Could we go to the next slide? We're going to move on in topics here. Many of you who tuned in to the earlier webinars have heard us stress the importance of having a transition committee, having a transition plan, and implementing that plan. We're gonna dig down a little bit on 3 of the specific tools that we're recommending for your toolkit: teleworking, scheduling, and staggering shifts, because we want to provide you with some really good practical takeaways from the webinar. But let me ask you a question before we get started, Julie. You know, as we jump into this, you've got let's say an employer's got most of its workforce working remotely. Can you just flip a switch and say, all right, everybody come back? Is it legal? Is it practical?
So it's a great question, Ron, and it's one that we're hearing a lot from employers these days. And you know, by and large, if a return to work plan or a stay-at-home order doesn't require a particular individual to stay home, and, you know, assuming that there's no other reasonable accommodation or other exigent circumstance, and Ellen's going to talk a little bit about that. You know, by and large, yes, you can require an individual to come back, but there's sort of another question there that we're, you know, posing and hearing from employers, which is, well, should you? And as you said, there are a number of practical considerations, both from the business standpoint, but also that we're seeing in some of these reopening plans that you should consider. But, you know, as it pertains to telework specifically, to the extent that you have employees who maybe have been working from home for the last 2 months or so and who can continue and who want to continue teleworking, we think that's a really great strategy to both meet social distancing requirements that you might be seeing in a return to work order from a state, as well as to meet some other requirements that might be in those orders. So if we can just quickly flip to the next slide. So we, McDermott, have been studying all of the reopening plans that have been coming out from both the federal government, most recently the CDC guidance that Ellen alluded to earlier, as well as the state and some local reopening orders that we have seen. And I mean, by and large, most of them, in fact, nearly all of them, specifically recommend continuing to allow employees to telework as appropriate, as feasible, as practical for your particular business. So just a couple operational considerations that you might think about as you're deciding whether employees should come back into the physical space of the business or continue to work from home. So as I mentioned earlier, will teleworking allow you to meet some social distancing requirements? Related to that, looking at your state plan, are there any building occupancy requirements that have to be met? So while in a lot of cases we're seeing that the state plans, for example, for a retail store or a restaurant, are requiring that employers only bring back, let's say, 20, 25, or 30% of people of the building occupancy. Again, while those specific recommendations might be apply, at least under a state order or state plan, to retail, restaurants, et cetera, it's actually really great guidance for other businesses to think about in terms of who do you want to bring back and when. And related to that, a lot of state plans have specific requirements for reconfiguring office space. And as a practical matter, you know, putting down tape on the floor, setting up partitions around workspaces, particularly if your workers work in a bullpen type environment where they may not naturally be 6 feet or so away from each other. Allowing certain individuals to telework is not only going to help keep them safe, but it may actually save you money in the long run to avoid having to reconfigure your office space to accommodate that during this period of time when they could continue to telework. And as we've been talking about, this is a great time to think about your telework policy. You might consider having an addendum or a supplement that is specific to COVID-19 so that given the fluidity of the situation we find ourselves in, that you don't have to continue to re-update your telework policy every time your state or the federal government maybe comes out with new guidance or a new order that applies to your business. You should also think about, to the extent that people are going to continue to work from home, what, if anything, you're required to reimburse for them, which may be different than it was when there was an actual stay-at-home order in place, as well as a practical matter, what you're going to choose to reimburse for them. And again, that should be documented in your policy. Now, if you make any sort of an exception, if somebody requests to work from home, be mindful of the fact that that is going to set precedent. So, for example, as it pertains to non-discrimination, which we were talking about earlier, decisions that you make need to be done in a non-discriminatory fashion using very clear criteria. You know, as a specific example, if you were to select, let's say, individuals who are over the age of 65, maybe individuals who are pregnant or who are immunocompromised, and to require those individuals to continue to telework while bringing back other individuals who do not fall into a protected category, even if the purpose of that division was to protect the individuals who are at higher risk of having a really severe impact from COVID-19, it might seem well-meaning, but it constitutes unlawful discrimination and could get you into trouble down the road.
Yeah, Ellen, I know you're going to cover the next few slides, focusing on teleworking and bringing it back to something you said earlier about this whole idea of, I know that you and I, when we practice, we use that phrase, no good deed goes unpunished, this whole idea of offering the opportunity for those who are in a high-risk category to stay home and work from home. What do you think about either having a policy or even making the offer to do that?
Again, to add on to the no good deed goes unpunished, I think questions like that come from a good place and a sincere place to protect our workforce, to go over and above in making sure the most vulnerable feel the most supported. However, I think, again, it's fraught with risk. I think the better question that I know many employers have been asking is, if you are offered the option to either go back to work or stay home, which would you prefer? And not limit that question to if you have a medical condition or if you have children. I think just throwing it out there to everybody and then taking that feedback as you consider how and who to bring back and when is the best. It's the best of both worlds, because then you're showing your employees that you're sincere in your care and regard for their variant personal and medical circumstances without singling employees out and being exclusionary, whether intentional or not.
Ellen, sorry, but there's a good opportunity to answer a question from the audience, and that is, if you're successfully teleworking and you've got a remote workforce and you're going to have certain people come back or require some to come back, there's no loss of pay, there's no adverse action, but you're having one group come back before another. Does an impact or analysis, formal, informal, apply at that point, even though there's really everyone's getting paid and there's no loss of benefits, but the benefit of being able to come to the office? What do you suggest there?
I do suggest, and I would call it an impact and potentially an impact analysis be done, because while impact analysis, many of us are used to doing those when we're doing layoffs or furloughs, they're also critically important when you're returning people to work, making decisions about who gets to stay home working remotely, because again, it goes to these unconscious bias issues that are going to drive litigation if employers aren't at the forefront of it. And so I do think doing some sort of analysis to make sure whatever groups you end up in, which buckets, staying home, coming to work, they reflect a variant in the diversity of your workforce that many employers have worked very hard to maintain.
Well, I know that before we go to the next, let's go to the next slide. We have our last and final polling question. And so for those of you out there that are in this transition stage, you're probably looking right away at the transition stage, or as we say, looking at your feet, but are you looking down the road as well? And so our polling question goes to that. Have you considered implementing a longer term staffing shortage survey to plan for future waves of the pandemic? That is, those peaks and valleys for those who tuned in to our earlier webinars that we all expect through the pandemic. if you could give us your thoughts. Yeah, I mean, I was smaller group. I think that this is sort of what I would expect, Ellen, and that is, you know, folks are focused on the actual return to work now. But our advice, and I know that your advice specifically, has been to look down the road and see where you're going in order to be prepared for those staffing issues.
Yeah, I mean, I think that I share in being in denial that this will keep on going on for months or maybe more than a year. But I think considering implementing a long-term staffing plan for future waves and doing so now gives you an opportunity to develop procedures, practices, protocols that are non-discriminatory, that are inclusive, that continue to motivate and encourage your workforce to feel supported in their positions. And I think, unlike with many of the decisions that we're forced to make now that are unfortunately reactionary to unprecedented times, there is a real opportunity to work with your workforce to anticipate the next stage of this pandemic. And so we do recommend them, once employers can take a breath from the current situation that we find themselves in. We wanted to also touch briefly on applicants with COVID-19 symptoms and what we can do with applicants. EEOC has also come out with important guidance. I think there are 5 questions in their guidance. I think this was issued back in March about what employers can do with applicants. After you make a conditional offer of employment, you are allowed to require an employee to do a COVID-19 test. If you may ask the employee if you have COVID-19 symptoms, you may delay the start date, and you may also withdraw a job offer when you need the applicant to start immediately. Now, the best practice in considering that last factor is, does your job requisition say must start immediately? If so, if you haven't thought about including those types of language on your requisitions, you may want to do that now if in fact that's an urgent need of the employer, so that you're not accused of disparate treatment when the worker might not be able to start. Can you go to the next slide, please? We get a lot of questions about what if an applicant is higher risk and fearful of contracting COVID in the workplace. You can't postpone a start date or withdraw a job offer because of their higher risk status. That should be self-evident. You can't not hire someone because they're of a certain age or have medical conditions. But the thing that we recommend is you engage in a dialogue to understand the applicant's concerns. You discuss possible accommodations. You talk to them about all the measures you've taken to make sure the workplace is safe and make sure they understand that you are their partner in ensuring that they can work safely at your work environment. After those steps are taken, you may rescind the job offer per the EEOC guidance. But you still want to have that dialogue. The same thing is true with respect to applicants who live with higher risk persons and are maybe afraid of coming to work in the workplace. The EEOC has not addressed this issue directly, but there's prior guidance with respect to discrimination based on associational discrimination. And so you would handle that type of question the same way you would handle an applicant who would have the same concerns. Again, in my view, communication is the way we're going to get through these types of real concerns that are presented by both applicants and employees. Can you go to the next slide? As far as the survey question, how do you plan for staffing shortages? What should be in a survey that you may want to conduct with your workplace? You may address the 4 questions that are on the slide. Do you need to care for a child if schools are closed? Do you need to have dependents? Are you unable to travel? Do you have a household member who could be affected if the public health authorities direct the worker not to come to work? You can ask those questions in a survey, and you might consider doing so. However, you need to ask them in a group so that you're not asking the employee to self-identify one or the other. And so, an interesting thing to consider, either now or in the near future as you consider what to do under the next wave.
I think that we're at the end of our presentation, and also at the 10:15 mark. We're going to take some questions. There are a bunch of them that we want to get to, but before we do that, we know that some of you need to drop off, and so want to thank you for joining. Our next presentation will be on Tuesday, May 26th, where we'll tackle some of those opening day obstacles. For those in New York, the validation code is BLUE21. We've gotten a bunch of questions. It is not case sensitive. It's just simply BLUE 21. And right at the end of the presentation, the recording and the slides will be made available. Julie, I know that there have been a bunch of questions in there regarding discrimination in the workplace, and I was hoping that maybe you could tackle a few of those for the participants.
Sure. Thanks, Ron. The first question, just as a tip, so we had a question specifically about the EEOC guidance and the date of that guidance. There's no specific number or acronym for the guidance, but it's available on the EEOC website. If you search for what you should know about COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws, you'll find it. Most recently, it was updated on May 7th, but we're finding that it's continually updated with new questions and even updates to answers. Now, there was a number of questions that we received about how long to keep temperature check records. The ADA requires that you retain that information from a year, from the date of making the record or from taking an employment action, whichever is later. That date may vary depending on your state law, so you should be sure to check in whatever states that you're operating, if there's a particular different time period.
Ellen, let me jump in here. There were a variety of questions regarding policies, and not only modifying the policies, but some of the new policies that are being created and the transition plan and our recommendation of what you want in writing, what you want documented. Could you speak to that a little bit? Because there are a bunch of questions regarding, do I have this in writing and why?
Sure. I think that one of the key things that has to be in a return to work policy or protocol is how are we selecting those people who are returning? What criteria are we going to rely upon? What criteria are we not going to rely upon? I think those, from a discrimination standpoint, to avoid claims of discrimination, you go back to the simple concept of when employees have policies that they understand, that they feel like they are being fairly treated under those policies, that saves perception of discrimination. It's one of the #1 things. Make sure employees understand what to expect. In addition to that, I think it's critical that a policy says, we need to be flexible, and we'll be flexible with you, and there's an open door to us if you have questions, concerns about any of these policies, or if you have concerns about coming back to work. If I could pick 2 aspects of a policy, those would be the major ones: to foster open door communication, have there be availability for feedback if whether an employee thinks a policy just, improperly impacts one group, there's a place to come forward, and then also setting forth the criteria. Here's how we're going to call you back.
There's a question regarding some of the thorny issues that employers are going to face, and I'd say it's within topic and slightly outside, and that is on the temperature taking. If you're going to require someone to take employees to take their temperature at home, we hear that a lot of employers are adding maybe 2 minutes or 3 minutes to non-exempt employee time for taking their temperatures, whether they're required to or not. They're doing it. So one, what are you open it up to the panelists? What are you seeing out there, and what do you think is the best practice? And if you actually are paying for the time, are you also suggesting paying for the thermometer?
I'll jump in on this one. In California, there's no de minimis rule anymore, thanks to a decision that came out in 2018. Any any activity that's required of an employee as a condition of employment is compensable. It is impossible to, you know, have a time clock installed at all of your employees' homes, nor do we suggest that. But you need to make a reasonable estimate of the amount of time that you're asking an employee to invest and make sure they're paid for that time. And then also have a disclaimer in the policy that says, look, if for whatever reason this takes longer than 2 minutes, 3 minutes, be paid for it, tell us about it. So at least if we're ever having to defend those types of lawsuits, we have a very fair and even-handed policy, which will go a long way, at least in California. In other states, there may be, the FLSA does allow for this de minimis time. You really got to weigh the risk of your state and what you're comfortable with in crafting a policy that's compliant with both federal and state law. As far as the thermometers, if you're going to require an employee to take their temperature at home, you need to compensate them for the thermometer.
I'll just briefly jump in on that. It's a slightly different situation, but I have seen that there have been a couple of lawsuits filed actually in California relating to companies that have required their employees to obtain PPE and then not provided that material. So the employees have to spend time going to purchase the PPE, as well as then there's the cost of the PPE. Now, while it's not the same as a temperature, and you know, it remains to be seen what the merits again of that lawsuit. I do think that there's potentially going to be a trend, and there's a risk there if there is an issue of compensable time spent taking a temperature or going to purchase it.
Yeah, that's a really good point, Julie. I mean, we are seeing the first wave of class actions out there, not only on the wage and hour front, but there were these class actions or potential class actions that are being brought against a client in the food industry, where it has to do with whether the workplace is safe or not, COVID-related lawsuits. So we are seeing that wave right now. Moving from PPE to PPP, however, Lindsay, I did notice that there were quite a few questions, compliance questions, with regard to the Act, and I thought maybe if you group them together and could take a few of those, that would be great.
Sure, absolutely. So there were some questions regarding what qualifies as a payroll cost, specifically whether or not severance would be one of those. On the outset in the CARES definition of payroll costs, that's your 75% allowable expenses permitted towards payroll. It was defined that severance is an includable cost with that. However, I want to couch that with one, just based on the other guidance that we've received from the SBA, especially in connection with the loan forgiveness application that was released. Want to make sure that it's both paid and incurred, or at least incurred at that time for marked severance agreement as documentation that can support it, and that during that time period, the severance paid that would be amounts towards forgiveness doesn't exceed $15,385, which is your cap for any payroll to any one individual during your 8-week loan period. One of the other questions that we're getting a lot, because this was part of the loan application forgiveness, which was a new issue, kind of was a change to the FTE count. So historically, the SBA had relied on the full-time equivalent employee definition that was included in the Affirmative Care Act, which was 30 hours or more. In connection with the loan application, which was released a little less than a week ago, I want to say last Friday evening, it was done and it was changed to 40 hours a week or more. So that's one of the new things that employers have to be mindful of when they're submitting their application. Also, one of the other big questions that we've gotten is whether or not the full-time equivalent employee count will be reduced by employees who resign, refuse to return from furlough, or if you had an employee that had to be terminated for cause, will you get a forgiveness ding or deduction based on that? And in the recent guidance that came out, the answer is no, as long as, one, you have the documentation to support it, to show that the employee was offered full-time position rehire at their regular compensation rate and refused, or the employee chose to initially resign themselves, or that the employee had to be terminated for cause, and then that you don't rehire someone in that employee's place. So essentially there would be no double counting of that FTE.
Thanks very much, Lindsay. You know, I know that we didn't get a chance to get to all of the questions. There were a couple of hundred questions. We tried to put them together in groups, as you saw at the end. If you have additional specific questions, we will try to follow up, but please feel free to reach out to any one of the panelists with a follow-up to your question, or if you are a McDermott client, reach out to your relationship lawyer. You know, we want to thank you very much for participating in the webinar series. Again, the next edition of the webinar series will be on next Tuesday and then next Thursday. We appreciate your participation, and we look forward to speaking with you again. Thanks very much, and thank you to the panelists as well. What a fantastic job.